once there is knowledge that there is a landowner and you are not possessing the land as an owner. So whether you are paying land rent, or you know you're supposed to pay land rent but you know you're not paying it, or you know somebody who have a deed and you know the person's identity, you've spoken to the person and asked them to build on this land, you've asked them to be here, you are on the lands or on the property and you are aware, you are not acting as if you are the owner. You have knowledge that someone else owns. That is enough to establish that you are not adversely possessing the lands and that you are not squatting, right? That you are aware that there is an ownership. Now, a squatter may know of an owner. So, for instance, you know that these lands are owned by the government, but you do not seek to obtain any sort of interest transfer or permission. You're just occupying there without permission. So in terms of the question you asked, can someone be related to you and squat on your land? Yes, but relationship to the landowner alone does not constitute as permission.
So you're looking at some sort of written
verbal action.
Verbal. I don't. Yeah, verbal, how verbal could go, right? Because communication is that much clear verbally. But what's important is that we know that unknown to the owner, you are on their land, qualifies you as a squatter, right? Unknown to the owner and the rightful owner, that is. So I don't know how many of you have been on our previous webinars, but we would have spoken about to length what it means to own land and what are the documents that would constitute ownership of land. And so just kind of touch on that, Mr. and Miss Daniel, in terms of my cousin parents died. They say, hey, 𝗦𝗂𝘂𝘶𝗲𝗿𝘀, we migrated to the States, go ahead. But I want to make sure that I am not in breach of any sort of legal obligation. What am I looking for? What is one looking for to demonstrate legal tenancy on the land? And what is the best way to fortify such?
So the only way the strongest way you can own any parcel of land in Trinidad and Tobago is by virtue of a deed. Now, there are several types of deed. There are common law deeds. There are certificate of title deeds. When you go into common law deeds, there are deeds by gift, where there's no financial transaction. That's like a father giving to his son a parcel of land and there's no money involved. Then there are deed of conveyances, that's where someone purchased a parcel of land. Then there are deed of assent, where someone died and my grandmother died and left a parcel of land for me. How do we get the deed from the deceased person onto the beneficiary? That is by virtue of a deed of assent. So, in a nutshell, once you have a deed to show that you are the owner of the land, then you are considered the owner as a freehold parcel of land. Then there are leasehold parcel of land, where ownership is exhibited by having a lease for the particular land. Their ownership can be by virtue of a deed or by virtue of a lease. And a lease is quite common now. There are a lot of townhouses doing leases. HGC sometimes give you leases. So because you don't have a deed doesn't mean you are not the owner, but just you are a different type of owner. You are a leasehold owner because the land is not freehold land. It's a leasehold parcel of land. So if you have a deed for the parcel of land, you are considered the owner. Not if you have it in your hand. If you have it in your name, you, I, Steve and Daniel, will be owner of the parcel of land by virtue of a deed or by virtue of a lease. Then you are considered, in strict sense, as the legal owner of the parcel of land.
Yes, And Mr. Daniel is absolutely correct. And I want to just touch on some of the points that you mentioned there, Stephen, because there are a lot of things that in doing my extensive public information outreach, I've recognized that there are several misunderstandings as it relates to what you just referred to, which is essentially property title, right? You would have mentioned about deeds and title under the RPO. And one time I want to, since we're talking about squatting, and somebody said that the audio is not very good. Let me know if you're hearing me, because this is an important point. When we're talking about deeds one time, I want to quickly also touch on the infamous deed of comfort, right? That people say colloquially, they term it deed of comfort, especially when we're talking about squatting. I want to categorically state in this webinar this evening to all persons present that no such document can legally exist. There is no such thing as a deed of comfort. You cannot have one. And this is because a deed refers to a written instrument of title that passes or conveys interest, rights, and ownership of property from one party to the other. And a deed of comfort does not do that. So therefore, it cannot be a deed because it does not convey ownership rights. It is supposed to be referred to as a certificate of title because the document itself certifies and gives the holder, and as Mr. Daniel mentioned, once you have the document in your name, not simply in your possession, but in your name, the holder of a certificate of title has a certified right from ejectment from state land if they have been squatting. So they have the right not to be ejected or evicted from the lands that they have occupied illegally. They have received a right for now to stay there in comfort. And that certificate of comfort now gives them the opportunity to apply for a statutory lease that gives them the entitlement to be granted a deed of lease for the state land that they have acquired. And if you're not certain about these things, you can visit the online information website of the Land Settlement Agency, where they make all these things very, very clear about holders of certificates of comfort, right? But there's no such thing as a deed of comfort. It is not an instrument of title. It does not give you title, ownership, right, or interest in the lands. And most importantly, it is a personal right, meaning that it is not transferable to any other party. So you cannot use a certificate of comfort to sell the land. You cannot use it to gift the land. You cannot use it to will the land to anyone. It is a personal interest to you, save and accept if you go through the process of regularizing that title by obtaining the statutory lease and by obtaining the deed of lease from the government. Only then you would have created title interest for yourself. But the certificate of title, the certificate of comfort alone does not do that for you. One person, so please remember that. And a second thing, and I realize that Mr. Daniel said it as well, and I think it's because, you know, everyday clients kind of say it. Persons say an RPO deed, right? No such thing either, right? That's because deeds are under the common law and RPO instruments are under the RPO system or the RPA system. They simply are just two different systems of title registration, one under the common law and one under the RPO system, which I think, Stephen, we got from the Australian, do you remember from school? Do you remember where we adopted it from? The Australia Torrent system, right?
Taking us back, you're taking us back.
Taking us back, taking you back. The Torrent system, I believe, the Australian Torrent system, right, is very similar to that. And that is registered title system where, and it's actually, that type of title registration is guaranteed, so to speak, by the government. Oh, right. So your title is sure. It is insured. So you could actually track properly and see at the back of your certificate of title all the transactions associated with your lands, rather than depend on, which is the common law system, which is a deed. You'll have to depend on the recitals or the story of the deed and say, whereas in 1972, 𝗦𝗶𝘂 had these lands and he gave it to Stephen Daniel. You don't have that in RPO. There's no story to tell necessarily, because all the endorsements are there to the back of the CT. So I hope I was able to clarify those two things, especially in this webinar, because we get that question every single day and a misunderstanding. Deed of comfort and RPO deed.